Apple and Amazon are accused of committing horrible illegal actions and collusion. This is a joint lawsuit against Apple and Amazon, and things are not looking great, because the result of this lawsuit might be catastrophic for these companies. The problem is that, in early 2018, there were around 600 firms on Amazon's marketplace where you could buy Apple devices, including independent refurbishers, frequently at lower pricing than Apple's own. By July 2019, there were only 7, according to a class action case, and this was due to an illegal agreement between Apple and Amazon. On behalf of Stephen Floyd, the law firm Hagens Berman filed the case in federal court in Seattle. With that, 2 days ago, Elon Musk came out and spoke about how Apple is too powerful and why everyone fears the tech giant. Elon surprised everyone when he said that there is a problem with Apple that many people are not aware of. This is a very interesting situation, so let's explain it. Floyd is a Pennsylvania resident who purchased an iPad for $320 on Amazon in early 2021 and was denied a cheaper option, which would have been the case in a healthy competitive market, according to the lawsuit. Apple's legal counsel and those who follow the company's legal history should recognize the name Hagens Berman. In 2005, the business sued Apple for damaged iPod Nano covers and ebook price fixing in 2011, and in 2021, it mediated a settlement for small iOS developers in the App Store. Hagens Berman has also been involved in a complex case regarding iOS touchscreen patents that had Apple accusing the law firm of surreptitiously relying on an extra counsel. Hagens Berman has also filed a class action Apple Pay lawsuit. According to the suit, Apple charges card companies $1 billion each year in fees for compelling them to sign up to Apple Pay as the sole means for their consumers to make purchases through iPhones and Apple Watches. Apple charges card companies a surcharge for each Apple Pay transaction. It's 0.15% for credit card transactions and half a penny for debit card purchases. While they are small sums on their own, they add up. According to the lawsuit, Apple earns $1 billion each year from these fees, and pushing card issuers to sign up for Apple Pay is an antitrust violation. The lawsuit primarily concerns Apple and Amazon's arrangement in November 2018. One extensively reported that enabled Amazon to directly sell Apple items through its marketplace, but also required any other business to seek Apple's authorization to sell its products on the site after January 2019. This effectively killed a significant source for refurbished Apple products, which tend to retain their worth considerably better in used and refurbished form than most other gadgets. According to the lawsuit, it was also an illegal lateral agreement between Apple and Amazon to remove or at least significantly decrease the competitive threat posed by third-party retailers. According to the lawsuit, the arrangement is a naked restraint and thus illegal under the Sherman Act. The Sherman Antitrust Act of 1890 is a federal legislation that forbids practices that impair interstate trade and market competition. It criminalizes any agreement, conspiracy, or combination of corporate interests that restricts international or interstate trade. Violations of the Sherman Act can result in serious fines. Although the majority of enforcement proceedings are civil in nature, individuals and businesses who violate it may face prosecution by the Department of Justice, DOJ. Criminal charges are often reserved for willful and obvious breaches, such as when rivals manipulate pricing or rig bids. According to the lawsuit, the benefits of this collusion were that Amazon got continuous supply at a discount of up to 10% if it kept illegal resellers out of its shop and quickly became the main distributor of Apple items on its site. Meanwhile, Apple allegedly removed the active pricing competition and was undermining its own retail prices. Prior to the deal, reduced pricing for iPhones and iPads from third-party suppliers on Amazon might have been 20% or higher, according to a blog post by an attorney with Hagens Berman. This same deal has already resulted in fines from Italy's antitrust regulator for limiting the companies that may sell Beats headphones on Amazon's Italian shop. An administrative court in Italy, however, overturned a $170.4 million punishment imposed on Apple and Amazon for alleged anti-competitive collusion in the sale of Apple and Beats products. In November 2021, Italy's antitrust authority fined Apple and Amazon $196 million as a result of an inquiry that began in 2020 over charges that the two firms were limiting resellers' sales of Apple and Beats gadgets in order to hinder competition and keep prices high. According to the regulator, contractual clauses of a 2018 agreement between the two businesses permitted only chosen resellers to offer the items on Amazon's Italian shop, which was in breach of EU laws and hampered price competition. Amazon was penalized $67.6 million, and Apple was fined $132.3 million. The watchdog also ordered the businesses to lift restrictions on shops selling authentic Apple and Beats items through the Italian Amazon web store in a non-discriminatory way. Apple and Amazon both filed appeals against the fines. Apple claimed, denying any wrongdoing, that they work closely with their resale affiliates and have devoted teams of specialists throughout the world that engage with law enforcement, customs, and merchants to guarantee only authentic Apple goods are sold. Amazon added in a separate statement that it completely disagreed with the Italian authorities' decision and that the proposed penalties were unreasonable and unjustified. The fine was decreased earlier this year to $170.4 million, owing to a material error in the first computation. The German Federal Cartel Authority has launched another investigation into Amazon as part of its ongoing campaign against tech giants. This time, Amazon isn't the only corporation that has been impacted. Apple is likewise scrutinized by the authorities. Amazon makes extensive use of so-called brand gating agreements, an issue that has received little attention in the antitrust field thus far. The probe follows several previous ones conducted by the German authorities, investigating Amazon, and focuses on the brand gating agreement's compliance with German antitrust law. Amazon is the subject of many current investigations by different competition authorities and may become a focus of future regulatory measures. Amazon, as a retailer, maintains the right to keep selling branded items. Amazon mostly restricts brand gating to major, well-known brands. In theory, though, the strategy might help any brand. Also, a few days ago, David Sachs wrote on Twitter how Apple is too powerful and that there has never been a tech monopoly as powerful as Microsoft in the late 90s and Apple right now. To this situation, Elon Musk publicly agreed and wrote that this is a very serious problem. Then Elon posted a tweet explaining the problem with Apple that not many people know. Elon said, "Did you know Apple puts a secret 30% tax on everything you buy through their App Store?" Well, one thing is for sure, Elon Musk and Tim Cook are a great relationship right now. And that's it for today. Subscribe to our channel and hit the notification bell.